Every time we have made an opportunity to be heard, we have not been given an opportunity to be heard by anybody. The Attorney General of the Republic of Kenya spent time in court last Wednesday begging for one thing, to be heard, that we would be heard to explain our side of the story on what is happening. We were denied audience and we couldn't be heard, and therefore none of our side of the story has been heard on this matter. So we're very grateful to you, honorable members, for according us the opportunity to explain to you what has been happening and the actions that the government has taken and how that is in keeping with the laws of the land and the international conventions and regulations to which we are all signatories. The overview of these, so that honorable members, Mr. Chairman, sir, I don't take you to a lot of detail. The background to this is a decision of the Constitutional Court by Justice Chacha Mwita ordering us to allow Mr. Miguna Miguna to come back to the country. The Honorable Judge made a very fair, objective and straightforward order that A, we facilitate, this is the language that the order uses, we facilitate Mr. Miguna Miguna to come back to the country and undertake whatever other activities he wanted to undertake, either A, using his Canadian passport, or B, we give him Kenyan papers at the airport. C, the Honorable Judge ordered that the Kenya National Commission on Human Rights is allowed to observe that process at the airport. So the advisory I received from both my peers and the Attorney General is that we comply in total 100% with the decision of the Constitutional Court. And based on that, our peers got in touch with Mr. Miguna's lawyers. Our Director of Immigration Services got in touch with the Kenya National Commission on Human Rights, and all was set for the arrival of Mr. Miguna on the 26th of March. When Mr. Miguna arrived, he refused to give his Canadian passport to be stamped because we had taken a decision that he did not even need to apply for a visa because of the court order. His passport was going to be stamped gratis. He would be allowed to come into the country without having to apply for visa. This is a courtesy extended government to government. He refused to surrender, to give his passport to be stamped. And for a whole day, there was a lot of drama. My peers will later on speak in some more graphic terms on what was happening. He was in constant communication with the lawyers at the airport. Later on in the day, one of them called me or looked for me, and I explained the issues the way they are. It's a straightforward issue, Mr. Chairman. It's a less than a half-a-minute affair to give your passport to be stamped and to come out. But he refused to give his passport. Then, of course, we resorted to number 2 order as directed by the judge. Against tradition and practice, we organized for the application forms to be taken to him at the airport. He tore them, he shredded them to pieces and refused to fill them out. We went beyond that because as government, and I can confirm to you, we were determined that this matter does not take so much of all our time. It is not necessary, honestly. I reached out to my colleague, the Cabinet Secretary for Foreign Affairs, and her peers to contact the Canadian High Commission so that the Canadian High Commissioner would extend consular services in the diplomatic manner in which they do to Mr. Miguna. The Canadian High Commissioner acceded, sent consular officers to the airport to meet with Mr. Miguna, and they spent 3 hours persuading him either to give his passport to be stamped or they could try to find a way of facilitating him in the diplomatic manner to get out of the airport. He refused. The rest is known to the public. Senior leaders in the political leadership of a party that Mr. Miguna belongs to also made an effort, and it didn't quite work out. His lawyers went to court, and I must say at this point, I lied to the court that A, Mr. Miguna's passport was confiscated, which is not true. One of the lawyers swore an affidavit to that effect. And 2, that he was, both of which were not true. Because, Mr. Chairman, as you know, according to migration rules around the world, until a passenger establishes himself or herself by going through the immigration section, they remain on the airside of the airport. And when they remain on the airside of the airport, they cannot be held in custody by the police. Mr. Miguna was not arrested, which is a fact. He was not in the custody of the Inspector General of Police. So there is no way the Inspector General of Police could produce someone in court who was not in his custody. I can say it here for the record, Mr. Chairman, honorable members, we did not confiscate Mr. Miguna's passport. And now, he has admitted himself and made the statement that actually the passport is with him, and he has admitted that he deliberately refused to give the passport to be stamped. On that day, on Wednesday, the Attorney General spent the day in court begging to be heard, because when the first judge made an order that Miguna be produced in court the following day, clearly the judge was not interested in the compliance with the previous judge's orders, and B, did not have an opportunity to hear from the Director of Immigration. And the Director of Immigration was being required to do the impossible. He could not produce somebody who was not already cleared and was not in Kenya. But we couldn't be heard. I mean, the judge flatly refused and said they could not hear us. At 1 o'clock, the same judicial officer made an order that the Inspector General of Police, the PS, and myself appear in court personally 1.5 hours later. Again, for the record, Mr. Chairman, honorable members, we were the GSU pass-out parade in Embakasi. Many of you, honorable members, in this committee are very exposed people, very experienced people. You understand this. Many of you have been in this sector before. The GSU pass-out parade is a Spartan straight ceremony that follows a tradition. You can interrupt in the middle. We don't even carry cell phones to that function. And we didn't know that such an order had been made until way after the function, when my PS Interior, Dr. Kibicho, said, by the way, an officer rang me up to say that you are supposed to appear before a judge. Said, but we have not even been served any court orders in the first place. And there is no way we would be there anyway because we were the GSU pass-out parade. I'm told the judicial officer said the GSU pass-out parade is not that important. And then, when the Attorney General begged even further, almost on his knees, that we have actually not been served, the judicial officer said, we have been on TV the whole morning. By now, the officials should know that we have ordered they come before us. Mr. Chairman, honorable members, we don't watch TV at the GSU pass-out parade. So, the long and short of it is that the Attorney General continued to plead that we be heard so that we can explain our side of the story, which did not happen throughout. The long and short of it is that we got finally condemned and heard, and condemned on the basis of lies. And now that I have this opportunity, Mr. Chairman, the Constitution says that Cabinet Secretaries are accountable to the people of Kenya through Parliament. Now I have to be accountable to you. And I want to say this for the record. I have not been served one court order. One. Not two. One. I have not been served any court order. And none of these, my brothers, has been served a court order. This is not a story. This is something that can be proved in a court of law. A judicial officer would ask for an affidavit of service, for example, to prove that I was actually served. I have not been served a court order. And actually, forgive me about the question of being served. I am not aware of any attempt to serve me or serve any of these officers a court order. So anyway, the long and short of it is that when it was impossible for us as government to do that which we were ordered to do, we were helpless. Our immigration department did not have an option but to remove, Mr. Chairman, I'm using these words advisedly, to remove Mr. Miguna as an undocumented and established passenger on transit to his last port of call. And I think it's important for everyone to understand this, especially even our friends and colleagues from the media. Mr. Miguna was not deported. Because if he was deported, I would have had to sign a deportation order. We couldn't deport him because he was not in Kenya. He had not been cleared. So he was not in our custody. He was not within our jurisdiction. We did not deport him. He was a passenger on transit who did not establish himself, who did not identify himself, who did not produce his credentials, and according to international convention, he was removed from the airside of the airport to his last port of call, which was Dubai, because that's where he came from. The reason why the Emirates carried him is because that is the plane on which he flew. And let me give you an example to demonstrate that, which amazes me that the media has not picked it. We have someone at the airport here at JKIA who has spent 4 months. Someone from an African country who has been here for 4 months at JKIA because they voluntarily renounced their citizenship of their country, took the citizenship of a country in the Middle East. When that country revoked the citizenship, he came to Nairobi, flew by KQ to his previous country or to his country of birth. When he arrived there, he couldn't be admitted because he had renounced the citizenship of his country. They shipped him back to his last port of call, which was Jomo Kenyatta International Airport. He has been here for 4 months. He probably has started a 5th month today. You read in the papers today about someone who has spent 15 years at the airport in Paris. This happens around the world. People need to understand how these immigration systems work. We are signatories to strict conventions that we have to follow. When these things happen, it has nothing to do with the government as it were. That is why the simple act of giving your passport to be stamped, and as I said, Mr. Chairman, honorable members, it takes less than half a minute for your passport to be stamped at the airport to be cleared. It's a requirement in immigration. You have to fulfill it. And no one is above it. Let me tell you, no one is above it. The Pope had his passport stamped here. President Barack Obama had his passport stamped here. Our own president, His Excellency President Uhuru Kenyatta, had his passport stamped there last night at 7:25 when he arrived from Mozambique. All of you honorable members travel, and when you come back into the country, your passports are stamped there. It doesn't take away your citizenship. It's a very simple act of migration. Last 2 things I would like to say before I invite my 2 colleagues. Our actions are guided by law. The Kenya Citizenship and Immigration Act 2011 was not enacted by the executive branch of government. It was enacted by Parliament. Our responsibility as the executive branch of government is to implement that law. It has got prescriptions on what happens when you have lost your citizenship, especially in the context of Constitution of Kenya 2010. Among the documents we are going to file, Mr. Chairman, honorable members, is a ruling by the Honorable Justice Isaac Renaola on a similar matter, in which Justice Renaola expressed himself clearly that anyone who deceives themselves that when they lost their citizenship before the Constitution 2010 was enacted, and they can gain it without going through the application procedure, is deceiving themselves. The law is in black and white. Since we enacted the law, Mr. Chairman, honorable members, 3,000 Kenyans, since the enactment of the law, 3,000 Kenyans have applied for their citizenship to be regularized. We call regularized because it's not essentially for them to be confirmed as citizens, but it's for their citizenship to be regularized. And by the way, Mr. Chairman, honorable members, they don't have to do that physically by being in Nairobi. Of the 3,000 Kenyans who have applied for regularization of their citizenship, about 2,000 of them in the US, in Canada, in the UK have done so online. They have written online, they have applied online, and they have had it all done. If Mr. Miguna wanted, he would actually do it from Ottawa or Toronto, wherever he is, and he would get it. It's a simple, straightforward process. We took these documents to him to the airport. He told them. We did all we could in that particular case to fulfill the requirements of the law. Did we comply with court orders and do we comply with court orders? Absolutely, Mr. Chairman. We always comply with court orders. Because there is evidence we have done that. There isn't a time we have been ordered to do something by the court and we haven't done it. In every aspect of this and many other things that we have dealt with, we have almost religiously complied with court orders, even when sometimes we find it very difficult to comply with those orders. But we have no choice. They are court orders, we comply with them. Did we, were we contemptuous of the court? I believe no. And that's why, Mr. Chairman, we have gone to the Court of Appeal this morning on the matter. And we are so dissatisfied with the manner in which this was done that we have filed a complaint through the Office of the Attorney General to the Judicial Service Commission on the manner in which the judicial officers who handled this matter conducted themselves. We were not heard. There was no evidence we were heard. They took decisions based on lies. And at the end of it all, we have been condemned, and you have all these shenanigans that you have here. Later on, I will demonstrate to you, and you especially, because you are members who are in charge of our ministry from Parliament. There's something I would like you members to know, and I will do a disservice to the country if I leave this sitting without letting you know that. Our ministry and our sector is the most affected by some of the decisions that are made by a section of the judiciary. The ensuring law and order is a very sensitive matter. On the crackdown on illegal gambling machines, I think I have over 30 or so court orders. On the crackdown on illicit brews, we have nearly 40 court orders. You know, and all these, the bulk of these orders are expired. In other words, someone walks into court, comes out with an order, and we have no chance of being heard. In this case of Miguna, of the over 13 or so court orders that have been made on this matter, about 11 of them are expired. In other words, we have not had a chance to be heard, you know, where you present your case. Because had the judge, for example, listened to us on Wednesday morning, they would have, for example, learned how difficult it is to get a passenger, like that gentleman who has been there for four months, to get him out of there and take him to court. How would you do it? Because he's on the other side, he has not presented his passport, he has no citizenship, he has nothing. How would you now smuggle him from there and take him to court? And then you're asking the Inspector General of Police to present someone they don't have, because he's not in our jurisdiction, he's not in our custody, we have not arrested him. So in conclusion, Mr. Chairman, honorable members, we obey court orders and we respect the decisions of the judiciary, and we always will, because if we don't, we will violate the law. Number two, that, however, imposes responsibilities on us and on our friends in the judiciary. The right to be heard is probably the most basic of all. We have not been served with any court order, and therefore we cannot be contemptuous of an order that we have not been served. Lastly, the Minister for Interior has no powers under the law to determine the citizenship of a person. That is why, if you read the Act, it uses language carefully. You regularize your citizenship after you have rescinded it yourself voluntarily, and prescribes the forms that have got to be filled. The 3,000 Kenyans who have done that already filled the same form. Every week, Mr. Chairman, honorable members, every month actually, I sign between 20 and 150 of those citizenships that Kenyans regularize. It's a simple form. I wish I would give you. It's a 5-minute form. It's a very simple form. And by the way, you know, it is not us who prescribed that. If you amended this act and repealed it, I wouldn't have to require the form, and the Director of Immigration Services will not require the form. So, which law is inferior to the other? What do we obey our whims and reject the law that exists in our statute books, as it were? So we've done the best we could. Mr. Miguna is free to apply, even now as I speak. But if he had gone to a computer when I started speaking, by now he would have completed filling that form. And by now, the form would be on the way from immigration to my office for signature. It's as simple as that. It's as simple as ABC. He doesn't even have to say, I'll come tomorrow or come next year. Or he can come this afternoon. He can anytime he wants. It's a simple, straightforward document that everyone who wants to do that fills. So I don't understand why it's an issue, as it were, at the moment. And then there's for the judicial officers, who actually include some of the lawyers who have sworn affidavits in court lying about actions that we have not taken. We will behave as responsible citizens. We will file a formal complaint with the Law Society of Kenya. And as I said this morning, I have requested the Office of the Attorney General, because the Attorney General is the bridge between the executive and the judiciary, to file a formal complaint with the Judicial Service Commission on that matter.